Hey there, I'm estate planning attorney Paul Rabelais, and in this video, I'm going to describe a not much discussed benefit of using a revocable living trust as the vehicle to transition your estate assets to the next generation. So there's quite a bit of material out there regarding whether people should use a last will and testament or a revocable living trust as the vehicle to pass their home, investment accounts, businesses, and other assets onto their survivors. Most of the commentary surrounding this concept emphasizes that the key benefit of using a revocable living trust to leave your estate to your heirs is that when you create your revocable living trust during your lifetime and transfer your estate assets to your revocable living trust, then, when you pass away, your heirs can avoid the court and attorney-involved probate process that is required when you die with estate assets titled in your name. You see, assets titled in the name of your revocable living trust when you pass away do not go through probate. Your successor trustee can immediately access these assets when you pass away and either distribute them to the beneficiaries you listed in your trust instrument or sell the assets and distribute the proceeds to your trust beneficiaries. But there is another benefit worth mentioning when you really want to dive deep into the will versus trust conversation, and here it is. In general, when someone creates a will or a will plan, that will generally say something like, "When I pass away, I leave whatever I own at the time of my death to my heirs." Specific assets are not typically listed in a will, unless you desire to leave a specific asset to a particular person or group of people. And since with a will plan, you simply leave everything you own in your name, there is no requirement that any effort be put into organizing what you own, consolidating scattered accounts, or making a good and detailed inventory of all of your assets and any debts. The thing about creating a will plan is that far too often, people get peace of mind and comfort from the fact that they have a good will in place. But when they die, they often leave a mess in the hands of their closest loved ones because those loved ones now are required to search for unknown scattered accounts, deal with the policies and procedures of multiple financial institutions, and quite frankly, never really be sure that they got everything that was out there that may have been in your name. In fact, it's not uncommon to take a year or two and complete a probate, and then lo and behold, some survivor locates some random shares of stock that was not known and accounted for in the probate. So the family, who at this time is exhausted with the complications of probate, has to go back and start a reopening of the probate to deal with one or more assets in the name of the deceased person that were not accounted for in the initial search of assets. So the bottom line on creating a will-based estate plan is that it is easier to set up than a trust-based plan for reasons I'll discuss next. But when someone creates a will-based estate plan, they have no duty or motivation to create the just as important detailed inventory of assets and debts that will have to be dealt with during probate. Now let's contrast that to what generally happens when you create a revocable living trust-based plan. One major difference between a will-based plan and a living trust-based plan is that the main benefit of the living trust-based plan over the will-based plan is that the properly executed living trust-based plan enables survivors to avoid probate. Now, the properly executed living trust-based plan not only requires that you create your living trust instrument and your pour-over will and your power of attorney and your healthcare documents that you have with a will-based plan, but in order to avoid probate, you have to retitle assets that you own from your name to your name as trustee of your trust. So, for example, if Fred Flintstone wants his survivors to avoid the expense and delay of probate when Fred dies, Fred will retitle his home, his investment account, his LLCs, and other probate assets from Fred Flintstone to Fred Flintstone as trustee of the Fred Flintstone Revocable Living Trust. This requirement that you transfer title of your assets to your living trust really requires you to take inventory of everything that is titled in your name so that, if necessary, you can retitle it to your trust. This forced examination and inventory of assets can be a great thing. While you are alive and well, you can gather your estate asset information, consolidate your scattered accounts, and then title them appropriately so that your survivors, upon your death, will not have to go on a wild goose chase for your assets, because as you create and maintain your revocable living trust, you will have been forced to efficiently consolidate and title this inventory of assets. In fact, at our estate planning law firm, we give each client a secure digital vault where they can inventory their assets and financial accounts, document how they are titled, upload estate and other important documents, and continue to update their digital vault as their life and estate changes. So that when you pass away, your survivors not only have the legal documents in place enabling them to avoid probate, but they also have all of the pertinent estate information at the click of a button, all making the estate settlement seamless and as pleasant as it can be. So in summary, it's not that you can go wrong with either the will plan or the trust plan, but the will plan is simple to create, but you just need your customized will and other ancillary power of attorney documents, but you typically don't retitle anything. Now, when you pass away, your survivors are going to have to gain confidence that their search of your estate assets is complete as they go through the probate process with lawyers and courts, because it's a hassle to reopen a probate to deal with a later discovered asset or account. But if you set up your revocable living trust plan, you'll leave your survivors with the legal instruments that they need to transfer trust assets to trust beneficiaries outside of the court and attorney-involved probate. And those who set up their revocable living trust plan are far more likely to have that comprehensive and consolidated asset inventory in place because they were forced to make that inventory as part of the trust implementation process. Hope that helps. I'll make this video part of my YouTube playlist entitled Reasons Americans Create a Living Trust. Make sure you like and subscribe and check the links in the description below for more information. We'll see you next time.